Okay. Hi, folks. We are going to get rolling on this lecture, which is going to be entirely pre-recorded. We're going to be talking about archives interacting with the law, specifically exploring copyright, patents, licensing, trademarks, intellectual property, all the works. Before we jump into this, I'm just going to say, I'm not a lawyer. You should always consult with a lawyer. Anytime that you are tangling with any of these questions in a professional context, I always highly encourage you to reach out to a lawyer, legal team. But the reason why I think that it's helpful for us to cover, and for us to cover now before we get into the real processing work, um, is because it's very helpful as you are interacting with donors, as you are ultimately going to be interacting with users as an archivist, to have a sort of foundational grasp of some of the concepts of how archives intersect with the law, how copyright works, etc., etc. So we're kind of just going to dive right in. I encourage you, feel free to reach out to me with any questions that you have about this. And yeah, check with a lawyer. So, first, we've talked a bit about this concept of custody. But let's give a real solid definition to what physical custody at least looks like. In an archival context, we think of archives as places where objects are stored. We preserve them for the future. So theoretically, most archives are going to interact with some level of physical custody. Physical custody covers the possession, care, and control of objects, especially for their security or for their preservation. So physical custody is who actually has the object. Um, uh, Oftentimes, archives will take in objects that they do not have the copyright for. The copyright may remain with the original creator still. In other circumstances, archives will insist that part of the transfer, when they have what's called a deed of gift, um, when the object is donated to the archive or the collection is donated to the archive, the copyright is transferred with it, or the intellectual custody of the object. Um, but like I said, a lot of different archives are going to operate under different circumstances, so it's important to separate these two concepts of the physical custody of who is retaining the object, and who has the intellectual control, custody, rights for the object in question. So, as a note here, physical custody is often paired with legal custody, where intellectual property rights are decided in addition to physical custody rights. But you're going to encounter many circumstances throughout your career where this is just not going to be the case for whatever reason. So let's give a little bit of a definition to intellectual property as well. Intellectual property is it sort of represents works of the mind. They're governed by copyright, patent, and trademark law. So let's think about a physical object. You may have physical custody of something like the work of Shakespeare as expressed in the First Folio. The First Folio has, I believe, 36 of Shakespeare's plays. You, as an archive, may have physical custody over that collection of plays. The intellectual property um, is not necessarily the script, but the work itself. So Shakespeare as a work that is performed in the world. That is considered the intellectual property. In the case of Shakespeare, it's public domain. He's been around a long time. But to give an example of a case where you may have physical custody but not intellectual property, intellectual custody, could be in like a post-colonial archive context, or even in the case of maybe you're collecting video from activists from the 1990s. you may have the physical custody of those videos. You're retaining them, you're preserving them, but you may not necessarily have the intellectual control or the copyright for those materials, uh, which means that you can retain them, but you can't necessarily license them or allow them to be used other places. So it's key that we separate these two concepts as we move into the process of describing intellectual control. So, as I mentioned, we have patents, we have trademarks, we have copyrights. I'm just going to give some broad definitions for these things. Again, um, always best practice to consult a lawyer. Certainly, no expectation that you're going to have all of this legalese memorized off the top of your head at any given time. But to separate some definitions out for what each of these different things are. A patent is something that you acquire for a new invention, a new process, or a new composition of matter, like a medicine of some kind. A patent gives you the exclusive right to make, use, or sell that invention, so long as it's novel, which means it's original in some way, it's useful, it has a use of some kind, and it's not obvious. So, for example, you could not patent a jar of air. You could not patent the process of retaining water in a plastic bottle. But you can patent something like a machine that can read your pulse through your like footsteps on it, or something like a new medication of some kind. This can be patented. Constitution specifically grants the United States Congress the authority to issue patents, which is codified in what's listed here. This particular provision. Um, but to give an example of what patents look like in practice, there's a fella you may be familiar with, especially if you're from the great state of New Jersey, named Thomas Edison. Thomas Edison, big old inventor, is at least how he's known. Thomas Edison had, I think, hundreds, if not thousands, of patents. Um, he did not invent everything that he patented, um, uh, but the patent gave him the exclusive right to be able to develop the whatever the invention or project that he had in mind was. The idea behind a patent is if you have a new idea or a new invention of some kind, it's going to take a little bit of time for you to, once you've created it for the first time, or once you have the idea for how you're going to create this new object, idea, concept, um, it's going to take you time to develop it, and it's going to take you time to be able to reproduce it and find a market for it. So patents protect inventors by giving them breathing room, time to develop their invention before it's able to be free reign for somebody else to develop a version of themselves. It gives you time to corner the market, time to develop your product, time to invent your invention. Most patents give you about 20 years for this process. I'm going to walk us through all of these different legalese with the example of guaifenesin. Guaifenesin is a nasal decongestant. You may be familiar with it through the brand name Mucinex. Guaifenesin was developed in the long period of time, but the version that we know that the patent exists for um, was developed in the late 1990s and the early 2000s. And the patent was granted to these three fellows, Robert D. Davis, Ralph W. Bloom, and Donald Jeffrey Kaiser. The patent was assigned to Reckitt Benckiser Incorporated. And what this patent provides is that Reckitt Benckiser Incorporated has the right to develop guaifenesin related um, drugs and combination drugs that would eventually become what we know as Mucinex and Mucinex Extra Strength. So the patent covers this product that we see on the left: maximum strength, fast max, severe congestion, and cough. Its two main ingredients in it is guaifenesin and dextromethorphan. Or sorry, dextromethorphan. Together, this combination of drugs in liquid form uh, is used to treat coughs, used for nasal and chest congestion, and for thinning mucus. It goes by the bottle name Mucinex Fastmax. And for 20 years, Mucinex had the patent for this. But now, this product on the right, you probably see products like this all the time in the pharmacy, generics, where somebody has taken the same combination of of ingredients and created a cheaper version of the same product. This version just goes by adult cough and chest congestion. It has the same flavoring. It is chemically almost identical to Mucinex. And now that Mucinex has had the 20 years to develop this product, get it into the market, become a household name, um, now the patent is expired, and you're able to see generics using the same combination of ingredients. So that's patents. Let's move into trademarks. Trademarks cover things like names for brands, names for brand characters and mascots, short slogans, or logos. Um, Actually, I'm going to revise that. Trademark is names, short slogans, or logos, not characters. We'll get into that in a sec. A trademark is a word, phrase, or design that is used to distinguish a manufacturer or seller's product, make it stand out as separate from the competition. In the case of Mucinex, we have this logo, we have the name Mucinex. This trademark was most recently renewed, at least when I took this screenshot in 2020. It's probably been renewed since then. Mucinex, excuse me, is based in Parsippany. And it was first used generally in 2007. Um, Here's various information that's available on Trademarkia, which is a useful resource for tracking down trademarks. But so this information, um, this is all related to the Mucinex brand. They own these trademarks. What separates these from a copyright is that trademarks describe and define a particular entity. Copyright describes a work. So trademarks are part of the design of what a company or an owner or something looks like. Copyright is the works that are produced by that entity, which could be an individual, could be a company like Mucinex. Original works include art, literature, anything created, really. And a copyright gives you the legal right to protect the interests of you, the creator, or anybody that you assign that right to by giving you control over reproduction, publication, adaptation, exhibition, or performance of the copyrighted work in any fixed media. So, I told you we'd be getting back to characters. Mr. Mucus is a copyright. Mr. Mucus this is the copyright.gov catalog record. Um, uh, he is the property of Mucinex. You cannot use Mr. Mucus, who I believe has like a wife and kids as well, without the approval of Mucinex. The foundation for all of these concepts of patent, trademark, and copyright is the United States Constitution, specifically Article 1, Section 8, which reads, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. Again, the idea behind all of these restrictions and designations is to protect an individual to be able to make their business, to be able to develop their invention and sell it theoretically without somebody with more money being able to just swoop in and to take that idea from them, theoretically. So we're going to be delving a little bit more into copyright itself and what the prerequisites are for a work to be protected by copyright. Comes down to these three limitations. First, the work or subject matter has to fall within a category of material that's protected by the Copyright Act. The material has to subsist in a matter that is original, that has an established author, and is fixed to some medium. And finally, the copyright has to not have expired. We're going to get into all of these things now. So first off, the work or subject matter must fall within a category of material protected by the Copyright Act. Most recent, um, most sort of binding version that is revised and iterated on is the Copyright Act of 1976, which covers literary works, things like books, poetry, prose, musical works, including any accompanying words, so both scores and lyrics, dramatic works, so plays, scripts, including any accompanying music. Actually, scripts would fall within literary works, but the dramatic performance itself, so the performance of what's on Broadway right now? And Juliet. The performance of & Juliet is copyrighted. The script for & Juliet is also copyrighted. But it's based off of Romeo and Juliet, which is no longer in copyright. Additionally, pantomimes, choreographic works, things like dance, are copyrightable. Pictorial, graphic, and sculptural works, so visual arts, motion pictures, and other audio-visual works. And then these last two categories are a little bit complicated. We'll get into why. They were added later in the game to being copyrightable. First is sound recordings, which is separate from musical works. Musical works is the music itself, the score, the lyrics, the actual music as it could be expressed by any particular musician playing from that score. The sound recording is the particular recording on, could be vinyl, could be a WAV file of a performance. For a long time, sound recordings did not have the same clear copyright um, protection as the music itself. And architectural work similarly was in a sort of gray area of not exactly being covered in copyright law until the mid 1970s and 90s. Again, get into that in a sec. Copyright also has to subsist in a particular work or subject matter having regard to originality, authorship, and fixity. What this means is originality, not aesthetic merit, is the basis for copyright protection. Something is not copyrightable just because it's good. it's copyrightable because it is original. Even banal images, quote unquote, or writings are eligible for copyright protection so long as they meet the threshold requirements. This is a good thing. This means that when you post a photo on Instagram of you and your friends, maybe you're at lunch and you post a photo of your meal together, a brand can't just scrape your Instagram page, take that image, and use it in an ad without your permission. Um, Even if the intention wasn't necessarily that your image was supposed to be something you were making money off of, you still have a right to it. Um, uh, AI works are generally considered not original. This is because of the nature of machine learning tools is such that machine learning tools are iterating on content that already exists, and judges have pretty consistently found that artificial intelligence um, generated objects are not considered original because of this. And not really adaptations either. They're sort of a category of their own, but one of two reasons why they fail to meet copyright. The threshold to be copyrightable is because they're not original. The second reason is that in order for something to have copyright, there needs to be an author. There needs to be some source of the original copyrighted work. Artificial intelligence is not recognized as an entity that is created, that is capable of authorship. So similarly, AI works are not able to be eligible for copyright because there is no author involved in those works. And also fixity, fixed in a tangible medium of expression is another way that this term has been defined. Basically, fixity means that a work was actually expressed in some medium, shape, or form. That's not just an idea that you had or that a thought that you had, but it was written down or produced. It was made in some format. Fixity doesn't necessarily mean that there's uh, direct that there's a direct product, but there needs to be evidence for the fact that something create was created. In the case of a book, this is a little bit more clean cut. It's fixed in the medium of a book. You have it in front of you. In the context of a play or a dance work or performance art, um, it is fixed to the medium of performance. It did occur, but the copyright is reinforced not because the object exists in a way that you can hold on to it, because there is ample evidence to for us to know that it took place. There's posters of production, there's playbills, there's all sorts of records and information related to happenings to prove that a work exists and is worthy of copyright. And finally, copyright needs not to have expired. This is going to get a little complicated. Copyright is has a limited duration on it. The intention behind copyright, similar to patents is that the idea is that one should have the right to make uh, money off of, or at least control the use of anything that they create for a reasonable period of time. Um, uh, Once the copyright expires, works enter what is called the public domain. Once you're in the public domain, that work can be used, adapted in just about any context without obtaining any copyright permission. Here's a quick definition of public domain: realm of works that are unprotected by copyright or other intellectual property rights. Works can enter the public domain without copyright expiration as well. A creator can relinquish their rights and allow their works to enter public domain automatically or without having to go through the whole expiration process. And there are other works that don't qualify for copyright, and therefore they will enter public domain automatically. So let's talk about expiration. Copyright law is complicated. And again, consult a lawyer anytime that you're uncertain. But I'm going to go over some of the broad understandings of like general categories of time and how copyright law works currently. If something was created on January 1st, 1978, or after it, you are dealing with the current set of copyright law. If something was created on or before December 31st, 1977, they fall within this category on the left. Any works before 1930 are automatically in the public domain. It's 95 years from their original creation. They are automatically in the public domain, no matter who they are. Side note, one reason why this is so complicated and these laws kept changing so much is because we have large media conglomerates to thank for the complication of copyright law, and large corporations who own large amounts of intellectual property, including certain animated mice and princesses and comic book superheroes, and the like, who want to be able to control Mickey Mouse's image. Disney was a big reason, not the only reason, but a big contributor to what made copyright law so complicated. But anyway, you have this period between 1930 and 1977. Works will periodically enter the public domain every year. It's not based off of the exact day something was created, but the year. So, uh, when we start a new year, a whole new batch of materials will enter the public domain. Everything from 95 years ago will enter the public domain in January of next year. So from 1930 to 1977, generally speaking, you're going to be in copyright for 95 years after publication, so long as the copyright has been properly and consistently renewed. Sound recordings, as I said, didn't used to be covered by copyright law, clearly. Instead, they were covered by state laws. So anything before January 1st, 1972, anything that was created before that date, have a range, usually somewhere between 95 to 100 years after their creation, that they're in copyright, depending on the state that they were created in. 1972 and on, all sound recordings are covered by federal copyright law. They follow the 95 year from creation rule. Architectural drawings, so blueprints and the like, before January 1st, 1976, um, are subject to a lot of weird and individual conditions. They're very complicated. If you're working with architectural materials, consult a lawyer. Architectural works themselves, that didn't necessarily qualify as sculptural works, but things like buildings, were only recognized as copyrightable in the early 1990s. Again, architecture in general, very complicated and convoluted copyright history, certainly something to consult your lawyer on. And there will be copyright exceptions in just about any medium, um, uh, especially 1977 and earlier. Things have gotten a little bit simpler since January 1st, 1978. Anything created after that point has two paths to the public domain. Either if a work was created by one person, that work will enter the public domain 70 years after their death. Or if there are anonymous or pseudonymous works, so works not under somebody's real name, or work made for hire, the copyright will be 95 years after publication or 120 years after it was created, whichever is first. So if a movie was created in 2005, but it's not released until 2045, let's say, it will enter copyright on in 2125, as opposed to uh, oh wait, as opposed to 2140, which would be 95 years after it was published. So whichever one comes first. Quick definition for this. Let me go back a sec. Quick definition for what I mean by work for hire. Work for hire is anything where one entity is hiring a creator that forfeits their copyright, their right to the copyright. Just about any film, just about any music, just about any television in the United States is considered work for hire. The artist relinquishes the right to that copyright when they sign a contract with that company who owns the copyright instead. Okay, so next couple slides are some charts. This is from the Cornell Copyright LibGuide. The link is on the left as you're looking through this slideshow. This is just to demonstrate to you how complicated some of this stuff can be. You are welcome to flip through and peruse this at your own interest. But the major takeaway that I would like you to have here is that this work is complicated, and we cannot all be expected to be experts on copyright law. We can do the best we can. Consult your lawyer. That's just going to be the ticker for this week. This particular slide is talking about works that were never published or never registered with the Copyright Office, let's say. Um, these could be also referred to sometimes as orphaned works. They merit talking about specifically because these are the sorts of materials that find their way into archives a lot, such as unpublished works, things like manuscripts, drafts, personal correspondence. These all sort of can fall within the realm of unpublished works. Generally, the copyright is held from the life of the author till their death, 70 years after their death. Um, if you, in the deed of gift, let's say that you received the papers of author Willa Cather, including manuscripts and correspondence. If in the deed of gift you are given the copyright to the material as well, you will have that copyright until it expires. Um, if the Willa Cather estate retains the copyright to the materials, then you can preserve the objects, you can make them accessible for people, but you can't publish them online, you can't license them yourself. You would have to direct people to go through the Willa Cather estate. Unpublished, anonymous, and pseudonymous works, as well as works made for hire, anything that's unpublished but was done under a contract, or was done for a company of some kind, 120 years after the date of their creation, the copyright expires. And in instances where the death date of an author is not known, we operate on 120 years from date of creation. If you cannot determine the date of creation either, great time to consult a lawyer. Um, uh, or using your best judgment, identify the sort of safety and risk factors involved before digitizing any objects like that. It certainly happens. It happens all the time, but it is worth a consult and a check with your legal team, whoever they are. All right. So we've mostly been talking about the United States up until this point, in fact, exclusively. But what if something isn't from the United States? Copyright law internationally can get really, really, really complicated very quickly. And there have been a lot of efforts over the years to try and create easier dialogue between different nations. You may be familiar with an author named Victor Hugo, author of Les Miserables and The Hunchback of Notre Dame. Victor Hugo um, was getting very tired of getting no money from his work being published in other languages in other countries, or even in the original French in other countries, and having either no or very little clear recourse to be able to sue for copyright. He pushed for many years for international dialogue on the topic of copyright and artistic rights. And he was a key figure to making the Berne Convention of 1886 possible. This established a codified agreement between all of the signatory nations that set sort of standard protections for copyright works, as well as clear pathways for international copyright disputes. It's currently signed by 182 countries. Additionally, WIPO is the World Intellectual Property Organization. They meet regularly to discuss matters of protecting copyright, improving creators' rights across the world. So, what rights does a copyright owner have? Let's say that you have the copyright to all of the materials in your given archive. Let's use a single object for this example. Um, I'm going to say we're going to use the example of Zora Neale Hurston's Their Eyes Were Watching God, which is a novel. If you own the copyrights to that novel, you have the right to reproduce it, to republish it, to publish it in a different context. Preparation of derivative works, you get to decide adaptations, sequels, prequels. You can make a cookbook that's inspired by Their Eyes Were Watching God. Um, excuse me. Distribution rights. So, how something is published, where it's published, if it's published in another format. Um, uh, the fourth is public performance, specifically for literary, musical, dramatic, and choreographic works, motion pictures, other audio visuals. If you have the copyright for a movie, you get to have a say in its distribution and where it is produced. Similarly, if you own the copyright for a play, you get to control when and where it's produced. A lot of creators will sell parts of the copyright to, like, for example, plays. A major rights holder is Samuel French, publishes a lot of plays, controls a lot of the distribution rights for plays. In addition to public performances, copyright also covers public display of works, such as motion pictures, such as posters, reproductions, and the like. Um, there becomes a little bit of a tricky question of how much copyright, how tightly it's enforced. I'll give you an example. Socrates Sculpture Park in Astoria, for many years, had a film series in the summer. Thousands upon thousands of people would come to watch independent art movies, pack the park full. The park was not necessarily paying distribution rights for these films. And there was an ongoing question, and I suspect part of the reason that these screenings don't happen as frequently anymore is because certain creators found out about this film series and said, "Hey, why are we not making any money from this? Why is this allowed to be distributed to such a wide audience without my approval?" Um, Compare that to a bar that has a movie on in the background. Um, the odds that anybody is going to have take any issue with a screening in a bar versus a large park event, you sort of have to balance the risk of what level somebody is necessarily going to go after you. And finally, you have the right for public performance of sound recordings via digital audio transmission, such as radio or YouTube. All right. Talked a little bit about AI already, but let's acknowledge it again. In the United States, AI generated works not able to be copyrighted unless you can prove that there is significant human contribution to whatever has been generated in the first place. Can deep learning models use copyrighted materials is, however, an ongoing question that is still being settled in court and will probably be um, contentious for a fair amount of years to come. Um, it's very difficult on the internet to set boundaries around what data artificial intelligence machine learning models can scrape. Excuse me. It's not impossible. For example, StoryCorps, where I work, um, artificial intelligence is not allowed to scrape our website. Um, uh, we have provisions around that. Artificial intelligence, like voice recognition models, are not allowed to use our audio library to train voices on. However, a lot of sites don't necessarily have these protections for their copyrighted material. So because of that, machine learning is kind of rampantly using a lot of copyrighted material to enhance its models. You could argue that there are some benefits to this. Speaking as a skeptic and somewhat a Luddite, would be more inclined to look at who would be harmed using technology like this. It risks diminishing or weakening the copyright, compromising the rights of the creator, and just generally, I would say not great practice. As far as what sorts of materials are acceptable for training these tools on. So let's talk about some exemptions to copyright. Um, uh, these exemptions specifically are oriented around use cases where you don't have to obtain permission from a copyright owner and you don't have to pay any licensing fee to use copyrighted content. The major case is what we call fair use, which is carved out in Section 107 of the Copyright Act, 1976. This is a provision that allows limited use of copyright materials without permission of the rights holder for non-commercial teaching, research, scholarship, or news reporting purposes. I've linked a fair use spreadsheet here. Things that fair use encompasses include classes like this. I'm able to share commercial material with you all without having to pay licensing fees because we're using it in an educational format. I'm not making money off of you reading the articles that we're reading in class. Similarly, researchers are able to cite portions of other copyrighted articles or books or film, whatever content they're citing, because it's part of the dialogue of the like intellectual dialogue of the piece, and scholarship wouldn't really be possible on the level that it exists if folks were not allowed to have some provision of being able to use this material. There's plenty of other instances of fair use. Um, uh, things like parody, satire, also fall within that, but I'm going to keep us mostly focused on the realm of libraries and archives. There is a separate section, the following section of the Copyright Act, that specifically carves out provisions for libraries and archives. This allows memory institutions to make a certain number of copies of copyrighted work for preservation or access reasons. Um, Libraries are able to distribute books for free, even though those books are copyrighted, because we agree that libraries are a benefit to society. Archives similarly are able to make access copies of copyrighted material, so long as the terms of those access copies remain compliant with copyright law. This does not cover digitization, generally speaking. To digitize something and have it live online where anybody can access it, generally you're going to need to have the copyright or permission to do that. But to be able to provide a copy to a researcher who asks for it, for example, that is covered in Section 108. Um, One major exception that is not covered in this is ebooks. Ebooks are not protected in reproduction law. A big reason why a lot of uh, book publishers are gung-ho on the switch to ebooks, even though uh, the book, no matter what anybody tells you, is not dead, and many people prefer a physical book. Certainly, other folks prefer ebooks. Um, uh, but there is a push on the part of publishers, a very strong push toward ebooks because libraries have to pay pretty large licensing fees in order to provide ebooks, as they are not covered in this provision. Um, uh, they will have to license those ebooks from the publisher themselves. So, um, this is the conditions around these provisions are justified if these three conditions are met. One, the reproduction or distribution is made without any purpose for direct or indirect commercial advantage. We're not making money from it. The collections of the library and archives are open to the public or are available not only to researchers affiliated with the Library of Archives. This doesn't mean that you have to have your archive open to anybody at any time. But there needs to be a process for anybody to be able to request information from your archive, even if you deny that request. And third, the reproduction or distribution of the work needs to include an attribution of some kind, a notice, an acknowledgement of the copyright. Okay, let's talk permissions. Permissions are when a licensor grants a third-party licensee, sorry, licensor grants a third-party licensee a license to use a work. Say that 7 times fast. Permissions include both physical and intellectual property rights, depending on the object. Can be one, can be the other, can be both. But licensors grant permission for objects to be able to be used. Permissions are often tied to a particular condition of use, such as the requirement that any reproduction include the name of the repository. If you are an archive, you may be operating on both sides of this continuum. If you don't own the copyright, you may need to request permission from your donor if you want to be able to digitize their collection, for example, and you'll need to get permission to do that. Similarly, somebody may come to you if you own the copyright for your material and they want to use it in a documentary or in some licensed purpose or some commercial purpose. Um, you'll want to, in whatever contract you have them sign, to giving them permission to use that content. you'll probably want to provide the paper trail back guiding people to your institution, telling them where the object came from. A license, just giving a definition real fast of what a license actually is permission or right granted to an individual or organization to enter a transaction, business, or occupation, or to take an action, allowing a non-copyright holder to use, publish, and or make money from a copyrighted item. Permission is granted through a license. So, most licenses have financial fees attached to them. This created a sort of tricky um, uh, two option system where for a long time you either retained the copyright for something and said that somebody needed to approach you in order to use or license the material in any way, um, specifically licenses that usually had money attached to them. The process of granting the license can be long and drawn out and complicated. Um, or if you wanted anybody to be able to use your object without having to constantly approach you every time, the only other recourse was to put it in the public domain, and then you lose all control over your object. Creative Commons in the United States has been built to sort of straddle the middle ground of many different scenarios or situations where an original creator or rights holder wants to retain some amount of the copyright, wants to have some level of intellectual control, but also wants material to be immediately accessible for other people or to grant certain permissions without having to draw up unique licenses every time. So Creative Commons is a type of license. There's many different iterations of Creative Commons. It's built on copyright law and it provides a standardized way for creators to give others the right to use and share their work. This is an example of what a Creative Commons license looks like. Anything that is in Creative Commons license is going to have probably some version of this icon. Usually it'll be on the web page that it's on, or the first page of a document, of a PDF, if it's a PDF. Um, but there are four circles here. The first one, the largest one, is most commonly going to say CC on it, meaning Creative Commons. That lets you know this is in copyright. It is a Creative Commons license. If it has a zero, then that license is telling you that it's in the public domain. You can use this object to your heart's desire, however you want to use it. Then we have these three other circles. The next one is your attribution. This tells you very briefly in a nutshell what do you have to provide in terms of attribution. If it looks like this, where it's a person and it says by underneath it, then you need to provide attribution. You need to say who originally created it. Ideally, you link back to the original source, be it a repository or wherever. If it has a slash through it, then you don't need to attribute at all. You are welcome to use it without attribution. Next is commercial status, whether you're allowed to make money off of this or something, or not. This slash through and NC underneath it signifies non-commercial. So you are not allowed to make money off of this object without getting copyright permission from the original creator. If there's no slash mark and it's just the dollar sign, then you're welcome to make money to your heart's content. And then the last one is adaptation status. How much are you allowed to remix, recontextualize, change, alter the material, and what format it was used in? In this particular one, ND stands for no derivatives, saying that no derivatives or adaptation of the work are permitted. Um, uh, essentially saying you can't just take this and adapt it into a different format. You have to use it uh, in a much more controlled atmosphere. Um, there's also SA, which signifies adaptations have to be shared under the same terms. The idea being that if this license applies to the original, then you need to use the same license for any adaptation you create. So for this particular example, the object that has this icon, what I would know from looking at this is that it's in a Creative Commons license. I have to give credit. I'm not allowed to make money off of it. And I can't uh, create a derivative or adaptation of this object without approval. So, thinking through digitization in particular, and its particularly thorny relationship with copyright, I'm going to step us through some potential scenarios or risks of digitized access efforts. These are sort of five big concerns around digitization for me. First is that the copyright status of the work may not be clear. If you don't know what the copyright of an object is and you digitize it, you run the risk of infringing on copyright law. Somebody could reach out to you and say, you need to take that down. Two, and then you spend all that time digitizing it, and even if they don't make you pay a fee, you've still lost money. Two, may not be possible to identify all of the subsisting copyrights incorporated into one work. In the case of a collection or something where there's multiple entities involved, uh, there may be multiple copyrights involved, and it may not be as straightforward as it may appear. Um, what all permissions you have, what you have control over. Um, Four, works that are in the public domain in the United States might be protected by copyrights in a different country. You may need to be careful. If you're digitizing something, you're digitizing it potentially for global access. So, terms being covered in the United States doesn't necessarily cover your actions in other countries. And finally, individuals and groups may believe they have more rights in material than the law allows and take umbrage when an institution digitizes that material. This is a more complicated way of saying just because you can do something doesn't mean that you should. And just because you have the legal right to do something doesn't mean that it's honoring the creator's wishes, um, and that it's best practice when you have the ability to do so. Reach out to the people involved, connect with them before digitizing their material, if you can, or at least make the honest and earnest effort to do so, and be open to if somebody comes knocking on your door a few years from now and says, "Hey, I would really prefer that that be taken down," that you have a clear takedown process. So, this is a relatively open and complicated question of what the archivist's role really is in protecting copyright and intellectual property rights. We are the stewards and custodians of objects. Often, their physical care is our number one responsibility. But we also have a role in protecting their intellectual um, uh, uh, rights, their intellectual property, the material itself. And I would argue that it's the archivist's responsibility to take care of our objects in our care, and that extends to making sure that when we are making things accessible, that we're honoring the intention and designs of the original creator, that we're paying people who want to be paid. Um, and if we are the copyright holder, that we take that responsibility seriously, and care with intention for where an object is placed, what context it's placed in online. Because as soon as something is posted online, you run the risk of losing control over it. or at least not full control over it. So be be mindful, be careful anytime you're digitizing. And I want to end on this note of talking about open access as a sort of philosophy that has guided archives for many generations now, at least since the sort of mid 20th century. Uh, Open access is the notion that archival resources should not be restricted unnecessarily, that we preserve things so that people can use them, that they should be accessible to the world. When archives were first being developed in the Western world, they were not necessarily intended to be used by everybody. But what sort of guides the principles of most memory institutions these days is the notion that folks have the right to access information. Open access has come under a fair amount of criticism in recent years um, uh, because um, uh, some of its critics would argue that not all material should be available. It's not necessarily a net good for all information to be available to all people at any given time, particularly in the context of colonized materials, in the context of stolen materials and materials of indigenous peoples. Um, there are thorny questions in relation to accessibility. Who should have the excuse me, the right to be able to access information? I would argue that the sort of final clause of should not be restricted unnecessarily um, is something that we should pay close attention to wording wise, because I think that the sort of guiding philosophy of open access and the idea that it's good for there to be more information in the world can go hand in hand with there are instances um, where caring for the objects and caring from the creators, you're caring for the creators of those objects and their inheritors, their descendants, um, that part of that care work does involve controlling or limiting that access to some extent, and that it is a necessary act in that case. It's part of the sustainability of that archive or that object. Um, so anyway, my 2 cents, I don't think that open access is as a philosophy is incompatible with some decolonial mindsets. Um, and I would encourage folks to think broadly and expansively about how both of these truths can be held at the same time. All right, that's a lecture. Thanks for tuning in. I have a short exercise for you on the class website. Take a look on the unit page. The exercise is really quick. You'll need to create an account on CUNY Commons if you don't already have one, and you'll post a comment directly on the website. If you have any questions, please feel free to reach out to me, and I will catch you soon.